Now we come to serving of summons to the accused person. There are, when you deal with CPC and CRPC, you have dealt with various modes of service of summons. So in the same manner, we are going to look into how the summons is served under CRPC. So the sections dealing with the mode of service of summons is section 62 to 67 actually. And now we just see what is the literal meaning of summons. What is summons? What is meant by summons? A summons in a case is of an accused person is an authoritative call to the accused to appear before the court of law to answer to a charge of an offense. So what is summons? It is an authoritative call to the accused person or the alleged person for what? In order to appear before the court of law. In order to appear before the court of law. And why? What is the reason why he's being summoned? Because he has to answer to the charge of an offense. A charge is filed against that person. So he has to answer that charge. So for that purpose, he is being called before the honorable court. So that authoritative call is known as summons. So in simple terms, we can say a summons in case of an accused person, it's an authoritative call to the accused person. For what? To appear in the court. Why? To answer a charge of an offense. Section 61 of the code explains the manner in which summons has to be prepared. So under section 61 of CRPC of the code, we can see in what manner the summons has to be prepared. What are the ingredients of the summons? So the basic ingredients of the summons is that it should be in writing. The summons should be in writing. That is the first point which is being stated under section 61 of CRPC. And it should be in duplicate. Either 2 or more copies should be there. It should be in duplicate. And it should be signed by the presiding officer of such court. Who is the presiding officer of such court? In which court is giving the summons, ordering the summons? That court, the presiding officer of such court should be signed. The summons should be duly signed by such presiding officer or by any such other officer as the High Court may from time to time or by rule direct. It may be either signed by the presiding officer or any such other officer as the High Court may from time to time and by rule direct to do so. So either by the presiding officer or any other officer as said or as the rules or as per the direction of the High Court, and shall bear the seal of the court. It should bear the seal of court which is pronouncing that summons, which is ordering that summons. So the basic a summons should include what all? It should be in writing, in duplicate, signed by the presiding officer or any other officer as the High Court may from time to time or by rules direct. So, and it should bear the seal of the court. So these are the basic things, in the manner in which the summons has to be served. And not only that, the summons should contain adequate particulars of the offense charged. The summons should contain adequate particulars of the offense which is charged against that person to whom the summons is to be served. That is the day and the time of the offense, then when and the place where the alleged offense was committed. The day, time, and when and the place. That is day, time, when, and where the offense has been committed. It should be included in these particulars should be included in the summons. So it is well defined, well stated in under section 61 of the code that summons, it should be in writing and it should be in duplicate. It should be signed by the presiding officer or any other officer as directed by the High Court, and it should bear the seal of the court. And more than this, it should include adequate particulars of the offense charged against that person. That is the day, the time, and the when, and the place where the alleged offense was committed. So all these are the particulars that should be included in a summons according to section 61 of the code. Hope it is clear. Now moving to the modes of service of summons. Which are the which are the modes of service of summons. It is dealt under section 62 to 67, various modes of service of summons. So first one is personal service. It is it is stated under section 62 of the code that the procedures of serving the summons personally to the accused person. Under section 62 of the code, it provides for the procedure for serving the summons to the person in person or personally serving the accused the summons. So clause 1 of the section, there are 3 clauses for section 62. The clause 1 of the section deals that the summons shall be served by a police officer. The summons to a person in person shall be served by a police officer or by an officer of the court, either by the police officer or by an officer of the court or by any other public servant in accordance to the rules that is made by the state government in question. According to the CRPC rules made by the state government, the summons must be served either by the police officer or any officer of the court or by any other public servant in accordance to the rule that is made by the state government concerned. Okay, so this is what is explained in clause 1 of section 62, that is section 62 subclause 1. Okay, now moving to clause 2 of section 62. Clause 2 states that as far as practicable, the summons should be served personally on the person summoned by delivering him one of the duplicates of the summons. So it is under clause 2 of 62, it states that it is practicable that the summons should be served to the person to whom it is summoned, and delivering that person the duplicate of the summons. And it is in clause 3 that states that that person upon whom the summons is served, he should sign at the back of the duplicate if asked by the serving officer. If such is asked by the serving officer, the person to whom the summons is served, he has to sign at the back of the duplicate copy. So this is what is explained for the personal service of summons under section 62 of the code. I hope it's clear for you all. Can I move on?
Yes.
Okay. Now moving to section 63. Section 63 deals with the service of summons upon any corporate bodies or societies. So section 63 of the code deals with the service of summons upon any corporate bodies or either societies. So according to section 63 of CRPC, summons on any corporate bodies and societies may be effected by serving it upon its secretary. Or corporate body, there is of course a secretary or local manager or any other principal manager of the corporation. The summons should be served to such dignitary, such person. So for the summons towards any corporate bodies or societies, it must be served either to the secretary or local manager or any other principal manager of the corporation. And the summons can be served by a letter sent through registered post to the chief officer of the corporation. The another mode is that the summons can also be served by means of a letter that is sent through registered post to the chief officer of that corporation. Here the service will be said to be completed when the letter arrives at the ordinary course of post. When the letter arrives at the ordinary course of post, the service will be said to be completed. The serving of summons is said to be completed. So section 63 of the code deals with the service of summons upon any corporate bodies or any societies. And according to section 63, it may be served to either the secretary or the local manager or any other principal managers.
Yeah, actually it is clear. So you can move on to 64.
Okay. Now going to section 64 of the code, that is service of summons upon the person who cannot be found. Serving a summons to a person who cannot be found. So section 64 of the code states that when a person who is summoned cannot be found, either after due diligence, then the summons may be served by leaving a duplicate with any adult member of his family residing with him. If the person to whom the summons is made is not available at that point, at that time, after due diligence, the summons may be served to any adult member of the family where he resides. Such an adult member must sign on the receipt of the back of another duplicate if asked by the serving officer. As stated in section 62, clause 3, here also, the person such receiving such summons may sign on the duplicate copy if asked by the serving officer. And there is an explanation to section 64, which states that the servant of that family, a person working as a servant in that family, is not included within the meaning of adult person of a family under section 64. So if the summons is served to any servant, it is not properly served. So it is well stated, well explained under section 64 of the code. Now moving to section 65, that is substituted services. So section 65 provides for the procedure when the service of summons cannot be effected after due diligence in any manner which we discussed earlier. That is according to section 62, 63 or 64. It cannot be delivered under any of the mode which we discussed earlier. In such cases, the serving of summons is in such a manner that the officer shall affix the copy, a duplicate of summons, on a conspicuous part of the house or homestead in which the person summoned ordinary resides. As we all know, in case the summons cannot be served in any other manner as explained under section 62, 63 or 64, in such cases, the officer can affix the duplicate of the summons on any conspicuous part of the house or the homestead in which that person ordinarily resides. The court may declare that summons has been duly served by the officer in such cases. Now moving to section 66, which deals with serving a summons to any government servant. So how can a summons be served to any government servant? It is dealt under section 66 of the code. And section 66 provide that for the service of summons to a person who is in active service of the government, in such a case, the court shall send a duplicate of the summons to the head of the office in which that person is working, that person is employed. And thereafter, the head officer must serve it to the person summoned in the manner provided under section 62 of the CRPC. That is, under section 66, if the person summons is a government employee, the summons has to be sent to the head of the office in which that person is an employee, and the head officer may serve the summons as described under section 62 to the person to whom the summons is summoned. The head officer must then return the duplicate of to the court under his signature, which shall be considered as an evidence of due service. And the head officer must return the duplicate to the court with duly signed, which shall be considered as an evidence of due service. So this is the manner in which the summons is served to any government servant under section, which is stated under section 66 of the code. Now moving to section 67, that is serving a summons to a person who is residing outside the jurisdiction of that court. So how a summons is to be served to a person who is residing outside the jurisdiction of the court, of that court. So under section 67, it states that when a court desires that a summons has to be served at any place outside its jurisdiction, it shall ordinarily be sent the summons in duplicate to the magistrate within whose local jurisdiction the person summoned resides or is to be thus served. So in such cases, the summons has to be sent in duplicate to the magistrate of under whose jurisdiction, local jurisdiction, the person to be summoned is resides, and it should be served from there. So this is the manner in which is stated under section 67, how the summon is served to a person who resides outside the local limits of the court. Now, this is the manner how which till here, section 67, it is the manner in which the summons has to be served to an accused person. Now we will deal with how the summons has to be served to any witness, that by post. By post, how can we serve the summons to any witness by post. Section 69 deals with the same, and according to section 69, it states that the court may, in addition to and simultaneously with the issue of summons to a witness, direct that a copy of such summons to be served by registered post addressed to the witness where he ordinarily resides or works. As in CPC, here also, by registered post, the summons has to be posted to the witness in the address where he ordinarily resides, or where he or she works. Then the summons will be considered duly served if it is signed by the witness or endorsement is made by the post office after taking the delivery. If the endorsement is properly done, we can say that the summons is duly served under this case. And so with this, I'm concluding my today's session.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional